Welcome to this lecture. In this lecture, we will discuss the defense of voluntary intoxication as is provided under section 23 and 24 of the Bharatiya Nyaya Samhita 2023. Corresponding section to section 23 and 24 of Bharatiya Nyaya Samhita is section 85 and 86 of the Indian Penal Code. Section 23 provides act of person incapable of judgment by reason of intoxication. A person capable of judgment by reason of intoxication caused against his will. This provides nothing is an offense which is done by a person who, at the time of doing it, is by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section 23 of the Bharatiya Nyaya Samhita corresponds to section 85 of Indian Penal Code. The early common law made no concession because of intoxication. The earliest case in England where the court approved the death sentence for a homicide committed in extreme intoxication is Reininger versus Fagosa. This rigorous law prevailed up to the early 19th century, although efforts by Blackstone and Cook to hold drunkenness an aggravation met with no success. Wharton held in view that there could rarely be a conviction for homicide if drunkenness avoided responsibility. Story stressed the law not permitting a man to avail himself of the excuse of his own gross vice and misconduct to shelter himself from the legal consequence of such crime. But the rule was gradually relaxed in later judicial decisions during that century, and law that is now actual insanity produced by drunkenness is the defense against criminal responsibility to the same extent as if it holds originated as if the same had originated from other causes. However, only involuntary drunkenness may be pleaded as an excuse but not voluntary drunkenness. The general rule in England appears to be that merely to show that a man's mind was so affected by drink that he more readily gave way to a violent passion is no defense. To this general rule, there are two exceptions. Number one, habitual drinking may occasionally lead to such permanent change in the brain tissues as to be accounted for insanity, such as delirium tremens and alcoholic dementia, where the intellect of a person has been permanently impaired by vicious habit. The reason for excluding the plea of incapacity are no longer applicable. Second exception, that involuntary drunkenness is a defense. This exception may be justified for the reason that the plea of involuntary drunkenness is not open to the same abuse as one of voluntary drunkenness, and the offense is not so likely to be repeated. As far as voluntary drunkenness is concerned, it was suggested in Rex versus Grindley that while, of course, voluntary drunkenness could not be an excuse, it should be considered in determining the issue of premeditation. Later on, in Regina versus Doherty, Stephen Justice said that you cannot take drunkenness as any excuse for crime. Yet, when the crime is such that the intention of the party committing it is one of its constituent elements, you may look at the fact that a man was in drink in considering whether he formed the intention necessary to constitute the crime. The exculpatory rule is not observed in cases that outrage public sensitivity. The intoxication, in order to be available as a defense, must be of that degree and extent as renders the defendant practically an automation, and the burden of proof of lack of capacity to entertain the required criminal intent is upon the defendant. The rule permitting disproof of relevant mens rea has been widely accepted. Bishop, summarizing the prevailing law, states, evidence of intoxication, therefore, is admissible for the purpose of ascertaining whether he was incapable of entertaining the specific intent charged, where such intent under the law is an essential ingredient of the particular crime alleged to have been committed. Indian law on insanity, Indian law on voluntary drunkenness. The Indian law on involuntary drunkenness is contained in section 23 of the Bharatiya Nyaya Samhita 2023. This section affords the same protection to an accused as section 22 to a person of unsound mind. In order to claim exemption from criminal liability under section 23 of Bharatiya Nyaya Samhita, the accused has to establish that, number one, that at the time of doing the act, by reason of intoxication, he was incapable of knowing, number one, the nature of the act, or that he was doing what was either wrong or contrary to law. And number two, that the thing which intoxicated him was administered to him without his knowledge or against his will. The phrase without his knowledge or against his will means the expression without his knowledge means ignorance of the fact that what is being administered is or contains or is mixed with an intoxicant. An act which the doer performed not out of his own conscious volition but on compulsion by some outside agency, by overpowering or paralyzing his will by overt physical acts, is an act against one's will. Voluntary drunkenness is no defense for the commission of a crime. Intoxication is a voluntary species of madness which is in party's power to abstain from, and he must answer for it. But where drunkenness is involuntary, as when a man is forced to drink, or when he is made drunk through stratagem or the fraud of the others, or through ignorance, or when any intoxicant is administered to him without his knowledge or against his will, his criminal act will be judged with reference to his mental condition at the time the act was committed. Such a case is exactly on the same footing as unsoundness of mind. The words used in section 22 and 23 are identical, and all the considerations that arise in case of insanity also arise in case of involuntary drunkenness. A very important case on the issue, that is Director Public Prosecutor versus Beard, is the leading case on the point. In this case, a girl of 13 years, while going to market, passed through the gate of a mill where the accused Beard was the watchman on duty. The accused attempted to commit rape. The girl struggled. Therefore, accused placed his hand over her mouth and pressed his thumb on her throat in a bid to prevent her from screaming. In this endeavor, he unintentionally killed her. The Court of Criminal Appeal found him guilty of manslaughter, but the House of Lords restored the conviction for murder. The following principles were laid down in this case. Number one, where a specific intent is an essential element in the offense, evidence of a state of drunkenness rendering the accused incapable of forming such an intent should be taken into consideration in order to determining whether he had in fact formed the intent necessary to constitute the particular crime. If he was so drunk that he was incapable of forming the intent required, he could not be convicted of a crime which was committed only if the intent was proved. This does not mean that the drunkenness in itself is an excuse for the crime, but that the state of drunkenness may be incompatible with the actual crime charged and may therefore negate the commission of that crime. Number two, insanity, whether produced by drunkenness or otherwise, is a defense to the crime charged. The distinction between the defense of insanity in the true sense caused by excessive drinking and the defense of drunkenness, which produces a condition such that the drunken man's mind becomes incapable of forming a specific intention, has been preserved throughout the cases. The insane person cannot be convicted of a crime. The law takes no note of the cause of insanity. If actual insanity, in fact, supervenes as the result of alcoholic excess, it furnishes as complete an answer to a criminal charge as insanity induced by any other cause. Insanity, even though temporary, was an answer, where the defense plea was that the accused was of unsound mind at the time of commission of the act, and the evidence established that he was suffering from delirium tremens resulting from overindulgence in drink. It was held that drunkenness is one thing and the disease to which drunkenness leads are different things. And if a man by drunkenness brings on a state of disease which causes such a degree of madness, even for a time, which could have relieved him from responsibility if it had been caused in any other way, then he would not be criminally responsible. The third thing, that evidence of drunkenness which renders the accused incapable of forming the specific intent essential to constitute the crime should be taken into consideration with the other facts proved in order to determine whether or not he had this intent. Fourth, the evidence of drunkenness falling short of proved incapacity in the accused to form the intent necessary to constitute the crime and merely establishing that his mind was affected by drink so that he more readily gave way to some violent passion does not rebut the presumption that a man intends the natural consequence of his act. The second point emphasizes the difference between the defense of insanity and drunkenness. It is only in the case of insanity that the accused appreciation of the legal implication of his conduct becomes relevant. The Supreme Court, in a case of Bablu alias Mubarak Hussain versus State of Rajasthan, held that in a gruesome murder case of wife and his three minor daughters and a son by the accused on December 9, 2005, there is no reason to accept the defense that these murders were committed by reason of accused being in a state of intoxication. The court in this case noted that after committing the 5 murders, the accused came out of his house at 5 a.m. and he started shouting that he had killed 5 bastards. The court held that these murders were premeditated, were planned and gruesome in nature, and therefore the accused deserved no sympathy, and the case clearly fell in the category of rarest of rare case. Section 24. Offences requiring a particular intent or knowledge committed by one who is intoxicated. Section 24 of Bharatiya Nyaya Samhita 2023 provides, in cases where an act done is not an offence unless done with a particular knowledge or intent. A person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Section 24 of the Bharatiya Nyaya Samhita 2023 corresponds to Section 86 of the Indian Penal Code. In the opinion of Sir E. Coke, as for a drunkard who is voluntarious demon, he hath no privilege thereby, but what hurt or ill soever he doth, his drunkenness doth aggravate it. Now, drunkenness does not more aggravate the offense, but drunkenness is an excuse and an act which, if committed by a sober man, is an offense, is equally an offense if committed by one who drunk. If the intoxication was voluntarily caused, where habitual drunkenness causes any mental disease and affects the mind, such disease is looked upon as insanity pro tanto. The leading authority in English law are men Beard and Gallagher. Beard has already been discussed under section 23. In R versus Mead, accused brutally attacked his wife and killed her by a blow with his fist. He pleaded drunkenness in his defense. He was convicted for murder. It was contended on behalf of the accused that the presumption that the appellant intended to murder was rebutted because, by reason of drunkenness, he had no such intent. It was held that a man is taken to intend the actual consequence of his acts. This may be rebutted in the case of a man who is drunk by showing his mind to have been so affected by the drink he had taken that he was incapable of knowing that what he was doing was dangerous, that is, likely to inflict serious injury. If this be proved, the presumption that he intended to cause grievous bodily harm is rebutted. It was further pointed out that if a man be too drunk to form an intention to kill or do dangerous bodily harm, he would nevertheless have been guilty of manslaughter, either because he intended to commit a battery upon his wife or else because he would have been guilty of gross negligence. In another case, A.G. for Northern Ireland versus Gallagher, there was an evidence that the accused was a psychopath and that his psychopathy was a disease of the mind which would be aggravated by drink in such a way as to cause him more readily to lose his self-control. When sober, the accused Gallagher indicated the intention to kill his wife. He then purchased a bottle of whiskey and he may have drunk some of it before he in fact killed his wife with a knife. The defenses of insanity and drunkenness were raised. The judge directed the jury to apply the test laid down in McNaughton's rule to the time when alcohol was taken and not to the time when the actual murder was committed. Then the Gallagher was convicted. Because in McNaughton's rule, the important thing is that the act must have been done at the time when he did that very prohibited act. The person must be of unsound mind at the time when he did the prohibited act. Lord Denning said that the case had to be decided on the general rule that drunkenness is no defense to criminal charge. He accepted two exceptions to this rule, namely, one, where drunkenness prevents the formation of a specific intent, and second, where a disease of the mind leading to a defect of reason within the McNaughton's rule was induced by drink. Neither of these exceptions was applicable to Gallagher's case because he was not suffering from such a disease and he had already formed the intention to kill before he took the whiskey. R versus Lipman is another case on the subject. Lipman and the deceased girl were both drug addicts. On one evening, after Lipman had consumed a quantity of the drug, that is LSD, at her flat, he began to suffer from hallucination. He began to suffer from hallucination and had an illusion of descending to the center of the earth and being attacked by snakes with which he fought. While in his hallucinatory state, he attacked her 2 blows on the head, causing her to die from asphyxia. He was charged with murder and pleaded that he had no knowledge of what he was doing whilst under the influence of the drug, and that he had no intention to harm the deceased. Lipman was convicted for manslaughter. It was observed that for the purpose of criminal responsibility, no distinction is made between the effects of drug voluntarily taken and drug involuntarily taken. No specific intent is necessary to support a conviction for manslaughter based on killing in the course of an unlawful act. And when a killing results from an unlawful act, no specific intent has to be proved to convict of manslaughter, and thus self-induced intoxication is no defense. In conclusion, it may be observed that drunkenness is a factor which will sometime have to be taken into account in determining the sentence which should be passed. Indian law, the law relating to voluntary drunkenness is contained in section 24 of the Bharatiya Nyaya Samhita 2023. A person voluntarily intoxicated will be deemed to have the same knowledge as he would have had if he had not been intoxicated. In some offences, a particular knowledge may be an ingredient. In others, a particular intent is an ingredient. This section does not say that the accused shall be liable to be dealt with as if he had the same intention as might have been presumed if he had not been intoxicated. There is definitely a presumption so far as knowledge is concerned, although there is no such presumption in offences requiring intention to constitute them. This section attributes to a drunken man the knowledge of a sober man when judging on his action, but does not attribute the same intention. In other words, the same knowledge will be attributed to a man in a state of voluntary intoxication as to a man not so intoxicated, but not necessarily the same intention. It is said that a man must know the natural consequences of his act, and if he knows what the consequences are likely to be, he must be held to have intended them. This inference from knowledge to intention would not arise when a man is drunk. Voluntary drunkenness under section 24 of the Bharatiya Nyaya Samhita does not afford a defense where merely knowledge required to constitute the offense was wanting, though it may be used to show that any intent to required was absent. That is, he can only be punished on the basis of knowledge and not of any particular intention. A very important leading case on the issue, Basudev versus State of Pepso, is the leading Indian case on the subject. Basudev was a retired military Jamadar. A boy aged about 15 or 16 had accompanied him to a marriage party. When they had gone to take meal, the appellant asked the boy to step aside so that he may occupy a convenient seat, but the boy did not move. This enraged the appellant, and he whipped out a pistol and shot the boy in the abdomen. The boy died. The appellant was drunk at that time. The question was whether the case fell under Section 302 Indian Penal Code, that is Section 103, subsection 1 of the Bharatiya Nyaya Samhita 2023, or Section 304 Indian Penal Code, that is Section 105 of the Bharatiya Nyaya Samhita. The Supreme Court, while holding the accused liable for murder, observed as follows. So far as knowledge is concerned, we must attribute to the intoxicated man the same knowledge as if he was quite sober. But so far as the intent or intention is concerned, we must gather it from the attending general circumstances of the case, paying due regard to the degree of intoxication. Was the man beside his mind altogether for the time being? If so, it would not be possible to fix him with the requisite intention. But if he had not gone so deep in drinking, and from the fact it could be found that he knew what he was about, we can apply the rule that a man is presumed to intend the natural consequences of his act or acts. Dr. Hari Singh Gaur summed up the law relating to intoxication as follows. He said, involuntary drunkenness, that is drunkenness caused without one's knowledge or against one's will, is an excuse. Voluntary drunkenness is an excuse only as regards intention, so that it is complete excuse in crimes requiring the presence of an intention to complete a crime. 3. But the voluntary drunkenness is no excuse for a crime which requires the mere presence of knowledge as distinct from intention. 4. In any case, though voluntary drunkenness is no excuse for knowledge, it does not imply actual knowledge, giving rise to the inference of presumed intention. What is the state of intoxication? The word state of intoxication means intoxication which renders a person incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law when he commits it. Drunkenness makes no difference to the knowledge with which a man is credited, and if a man knew what the natural consequences of his acts were, he must be presumed to have intended to cause them. But this presumption may be rebutted by his showing that at the time he did the act, his mind was so affected by the drink he had taken that he was incapable of forming the intention requisite for making his act the offense charged against him. Some cases in Dasa Kandha versus State of Odisha, the plea of the accused that under the influence of liquor he could not have formed the requisite intention for committing the murder of the deceased. Hence, his offense be treated as culpable homicide not amounting to murder was not accepted. It was held in this case that the normal presumption is that a man intends the natural consequences of his act unless rebutted by the accused by giving such evidence of drunkenness as might have affected his faculty of understanding to form the requisite intent. In this case, the plea was not accepted because of the clear and cogent prosecution evidence which established the guilt of the accused. In another case, in Sarthi versus State of Madhya Pradesh, three drunken accused persons had overpowered the deceased and made him unconscious by rough handling. They had, thus, the specific intent to cause grievous hurt till then. But the question with regard to the intent became dubious. But the question with regard to the intent became dubious when the accused person hanged him from the ceiling without taking steps to ascertain whether he was dead or alive. The recklessness and gross negligence on the part of these accused, under a state of intoxication, gave the accused a benefit to be convicted for the culpable homicide not amounting to murder instead of the offense of murder. In Gautam Bhile Ahir versus the state of Maharashtra, the appellant accused Gautam Bhile is the husband of victim Reena Bai, who were married about 8-9 years before the incident and had one son and one daughter. The accused was addicted to liquor and he suspected about the character of his wife Reena Bai. He used to beat Reena Bai and Reena Bai disclosed this fact to her parents whenever she visited their house. In November 2006, both wife and husband had gone to Reena Bai's parents' house to attend marriage of Reena Bai's younger sister. There again, Reena Bai disclosed to her parents about ill treatment of Gautam. His husband assured not to consume liquor in future and also not to ill-treat Reena Bai. After marriage, Reena Bai and her husband came back to husband's house. On 6 February 2007, the accused Gautam Bhile, under the influence of liquor, beat his wife Reena Bai and threw an ignited traditional kerosene lamp chimney on her person, due to which her sari caught fire. She herself attempted to extinguish the fire, but in that attempt she fell into a nala. Thereafter, the accused admitted her in a civil hospital. Her statement was recorded by ASI, police, and a special executive magistrate. In both her statement, she had stated that her husband threw an ignited lamp over her and she caught fire. On hearing the incident, the mother of Reena Bai also visited her in hospital and Reena Bai narrated to her mother that on 6 February 2007, at about 6:30 p.m., when she was alone at her house, the accused under the influence of liquor beat her and threw ignited lamp on her person, due to which her sari caught fire. On 6 February 2007, at about 10:10 p.m., in case for the offense punishable under Section 307 and 323 of Indian Penal Code, that is Section 109 and Section 115, subsection 2 of Bharatiya Nyaya Samhita, was registered on the basis of her dying declaration. But on 9th February 2007, she succumbed to her injuries, and thereafter the offense under Section 302 IPC, that is Section 103 subsection 1 of the Bharatiya Nyaya Samhita 2023 was added. During the trial, the accused pleaded alibi that he was not present at his house at the time of occurrence. It was held by the Supreme Court that whenever defense of alibi is taken by accused, the burden to prove that accused was elsewhere at the time of occurrence would be on the accused. It was further held that the benefit under Section 86 of Indian Penal Code, that is Section 24 of the Bharatiya Nyaya Samhita, would be available to a person if intoxicating substance was administered to him against his will or without his knowledge. Since in this case, husband himself had taken liquor, therefore he was not entitled to claim benefit of Section 86 of Indian Penal Code or Section 24 of the Bharatiya Nyaya Samhita. In this case, the deceased in her both The dying declaration had clearly stated that her husband used to consume liquor and beat her under the influence of liquor. Dying declaration made to mother of deceased fully corroborated the two written dying declaration. Since her mother met her after recording of dying declaration by police and magistrate, there was no possibility of tutoring her. Deceased was in fit condition at the time of making her dying declaration. Therefore, conviction of accused on the basis of dying declaration was held to be proper. A and B, example, two friends together consume an intoxicant. Being intoxicated, A begins to believe that a wild beast has attacked him and under this delusion kills B. Here A is liable for culpable homicide not amounting to murder because he was voluntarily intoxicated, and voluntary intoxication is an excuse only as regard to intention but is no excuse for offences requiring knowledge. Now the difference between section 23 and section 24 of Bharatiya Nyaya Samhita is, in fact, section 24 is an exception to section 23. Section 23 covers the entire offences relating to intoxication, whereas section 24 takes care of offences requiring specific intention and knowledge. Section 24 lays down that if intoxication is involuntary, then there is neither knowledge nor intention of committing the offense. But if it is voluntary, then only knowledge can be imputed and taken into account, and intention will no longer be considered in the case.